about the final rulemaking process and some of the specific changes that were made over the proposed rules. And then we're going to talk about these changes to the rules and the rules overall from the petitioner's perspective and from the patent owner's perspective towards the end of the webinar, focusing on strategic issues. And then to the extent we have any time left, we'll have a question and answer period at the end. Before we get into the presentations, let me start by welcoming our two honored guests who have graciously agreed to join us from the USPTO as part of the office's mission to communicate with the public. First, I have the honor to introduce Deputy Undersecretary of Commerce for Intellectual Property and Deputy Director of the USPTO, Theresa Ray. Welcome, Ms. Ray.
Thank you.
As many of you know, Ms. Ray joined the USPTO from private practice. She was previously a partner at Crowell & Moring in D.C., as well as a past president of the AIPLA, so certainly approaches problems in intellectual property law with the benefit of a practitioner's perspective. And I'm also honored to welcome today with us Chief Administrative Judge James Smith. Welcome, Judge Smith.
Good afternoon.
Judge Smith, of course, has also had extensive experience prior to his work for the board, having served in-house at some major corporations, including Lexmark, Nokia, and Baxter International. He's also served as the Assistant Dean of the Law School at Emory University and has worked at two major law firms and as a Federal Circuit Clerk. Thank you for joining us.
Thank you so much.
I'd next like to introduce my colleague at Foley and Lardner, Andy Baluch, whom we are happy to have back at Foley after a stint in government where he also served as a Federal Circuit Clerk and then as legal advisor to the Director of the USPTO and finally as the Director of International IP Enforcement in the White House Office of the IP Enforcement Coordinator.
Thank you.
Just a few housekeeping items before I turn it over to Deputy Director Ray and Chief Judge Smith for their presentation. First, we're offering this webinar as continuing legal education. To be eligible for CLE, you must be logged in and dialed in for the duration of the webinar. For those of you who are seeking CLE credit in New York, you are unfortunately required to complete a form which is provided in our printable materials, and that form requires a 5-digit code which we will be providing at a random time during the presentation. We will also be taking questions during the webinar. There will be a time towards the end of the presentations that's specifically designated for Q&A, but you can pose a question during the presentations by going to the Q&A box at the top left of your live meeting toolbar, typing it in, and then hitting enter on your keyboard or clicking ask, the ask button to submit. So the questions will not immediately be posed to the speakers. What happens is they go into a queue. They'll be reviewed and posed if possible, and I'll be the one deciding whether or not we can pose them at that point in time. We do have a lot of people on the line today, so it may not be possible to ask each question. And it may be that I will just wait on certain issues because I know that they'll be specifically addressed a little bit later in the presentation. I think given the September 16th transition, there are a number of you who probably right now are working on petitions for Interparties review. And you probably have questions specifically for Deputy Director Ray or Judge Smith on how to interpret the rules, and I think that's great. It's one of the points of doing a webinar like this. So I will try to give priority to those questions that relate to the filing of Interparties review or covered business method review petitions, with the understanding that our USPTO guests can address interpretations of the language of the rules and the process by which the rules were made, but probably won't provide strategic advice for specific situations. So if you're asking that kind of question, you might end up with Andy or me answering it. So with that, I would like now to turn it over to Deputy Director Ray and Chief Judge Smith for their presentation.
Thank you so much. Matt, that was excellent, and I'd like to, at the outset, thank Matt Smith as well as Foley and Lardner for coordinating this fantastic event. At the outset, I'd like to say that from the PTO perspective, this is extremely timely, and that we want to help the outside practitioners to the extent possible get up to speed as quickly as possible because time is imminent. As you know, these will be implemented September 16th, these procedures, and we hope to handle each and every one of them in 12 months or less. I'm going to go through a basic overview of the AIA trial proceeding structure. Judge Smith will go into the Interparties review, post-grant review, covered business method patent topics. And then lastly will be the umbrella rules and a brief discussion of even the practice guide. However, we're going to break that up a little bit between Judge Smith and I. I should tell you at the outset that the Federal Register notice might appear to be a bit dense, but it is easy reading once you get the swing of it. And to those of you who have not yet embarked on reading the Federal Register, I recommend that you start with the umbrella rules and the practice guide, because that sets the foundation for you. In particular, the umbrella rules set forth details on who can practice here before us: mandatory notifications, filing of evidence, discovery, protective orders, sanctions, oral argument, final decisions, and even settlement. And then the practice guide provides a general framework of our proposed regulations. It gives you the structure and the time for taking actions. It gives you a very nice timetable. It also asks you to identify the real party in interest, and it provides information on our protective orders. So for those of you who have not read the Federal Register notice yet in detail, we strongly recommend you start with the umbrella rules and then proceed for the individual IPR, PGR, CBM final rules. Our AIA trial proceedings, the way we think of it here within the office, is the top left corner of the screen shows Interparties review, then post-grant review, the top right, covered business method, and derivation. Now, right now, what's probably on most people's minds is the Interparties review, because when we're ready and open for business on September 16th, we expect a fairly large surge of filings within the first day, if not the first week. Post-grant review for most of you on the telephone is not going to be highly relevant at the outset, because those only apply to patents that are filed after September 16th of this year. So actually those are only patents that are actually in the first to file world, which is March 16th, 2013. So most of you won't have a chance to file the post-grant review type proceedings for quite a while. The covered business method patent review is also something that is probably most of you won't have a need for in the immediate time period, but those are a subset of post-grant review. The bottom right corner, derivation proceedings, we actually have derivation proceedings today. Those are a subset, if you had a Venn diagram, of our interference proceedings, and the derivation proceedings refer to when one inventor derives or borrows subject matter from another, and they want the correct inventive entity to be named. The umbrella rules cover each one of those 4 trial proceedings. Now here we have a very quick timeline for you with the AIA trial proceedings. PO means patent owner, and what we have here for you right now is a petitions filed the top screen, at the far screen on the left, and then the patent owner has a chance within 3 months to file a preliminary response responding to the third-party petitioner's request for claims likely to be canceled. And then the patent owner, however, I'd like to point out, is not required to respond. And as a matter of fact, within the statute, Congress anticipated that. So a patent owner has the option whether or not to respond. Within 3 months or less after that, and we are hoping that we handle these in less than 3 months, our lead administrative patent judge will determine whether or not the threshold has been met by the third-party practitioner and whether or not we will actually start a trial proceeding, for instance, an inter-parties review. The rest of this timeline is actually described quite well in our practice guide, so I think I will leave that to you later. Now, the major differences between inter-parties review, post-grant review, and covered business method patents are very important. At the present time, the ones that everyone should be focusing on, of course, are the ones that we will probably get many of in the soon-to-be near future after September 16th, the inter-parties review. There it's important to realize that all patents are eligible, whether they were in the first-to-file world, the new first-to-file world, or in our first-to-invent world, which we are living in now. There are some restrictions with the Interparties review, and that's that the third-party petitioner cannot have already filed an invalidity action, for instance, in a U.S. district court. In our Interparties review, only Section 102 and 103 grounds of rejection can be used, and so they're based on patents and printed publications only. Now, that's consistent with our current Interparties re-examination. Interparties re-examination, the last one can be filed September 15th of this year, 2012, and then Interparties re-examinations cease to exist, and this new AIA trial proceeding, Interparties review, starts on September 16th, 2012. The second column goes into our post-grant review proceeding. As I indicated earlier, that only applies to the first-to-file or first inventor-to-file patents, and that first one will not be filed until March 16, 2013. Once again, the third-party petitioner does not have access to this proceeding if they have already filed an invalidity action in another forum. And there's restrictions actually in the statute telling you when it's appropriate to file them. The last box under post-grant review is probably the most interesting, and that's that issues that can be addressed in the post-grant review go beyond the 102s, 103s, beyond novelty and obviousness type issues. You can see that 101 patentability issues, 112 written description and enablement issues are fair game. The only thing that is not fair game is best mode, because while the America Invents Act did not address the requirement to file best mode in all patent applications, and I strongly encourage all of you to do so, the America Invents Act no longer allows third-party challengers, patent challengers, to try to invalidate a patent based on best mode. So it cannot be used as a sword any longer. The column on the right, the covered business method patents, apply both to the first to invent and first inventor to file world. These we could end up seeing very soon on September 16th, 2012. So all patents are eligible, but they have to relate to a covered business method patent. They cannot relate, however, to a technological invention, and we have a separate Federal Register notice on that technological invention. In order to file one of these requests on a covered business method patents, the third-party petitioner must have been sued or charged with infringement before they are able to file one of these proceedings. Once again, I analogized early on that the covered business method patent really functions as a PGR, as a post-grant review type procedure, and that's because of the bottom box where, once again, just like with PGR, covered business method patents can be challenged on a basis of 102 and 103, but also 101 and 112 issues. Of course, best mode is eliminated and is not available there either. Now, this next slide on page 12, for the Interparties review and post-grant review / covered business method patents, in terms of the threshold that we're looking for, we're not looking for an SNQ, a substantial new question of patentability, but rather Congress gave us a what they thought was a higher threshold to be met. In the case of Interparties review, the third-party petitioner must demonstrate in their filing, in their petition, a reasonable likelihood that the petitioner would prevail as to at least one of the claims challenged. You could see our little arrow at the very bottom that Interparties review, actually if it's a 50-50 chance, we are likely going to grant the petitioner's request and start the IPR proceeding. On the other hand, in the case of post-grant review and covered business method patents, Congress said that their third-party petitioners must demonstrate that it is more likely than not that at least one of the claims challenged is unpatentable. Now, there it means it's more than 50% chance that at least one of the claims is unpatentable. So the hurdle for PGR covered business method patents is a bit higher. I have another slide here, and this is the final one that I will be going through, and that's that for our administrative patent trials, the top arrow relates to the first to invent patents, the world in which we currently live. The arrow on the bottom relates to first inventor to file patents, the first of which that can be filed March 16th, 2013. So if we go to the top slide, or the top arrow, the first to invent patent, the covered business patents are fair game and can receive one of these proceedings within our trial division after issuance. So you can file something in the first to invent patent world on the covered business method patents. If somebody else has granted a patent, you can file, a third party can file one of these proceedings immediately should they want. Now you can see at the right of that top arrow, it has also mentioned that in the first to invent world for Interpartes review for patents other than business method patents, you have to wait for 9 months from the issue date. So an Interpartes review in the first to invent world cannot be filed until 9 months after the patent has been issued. The bottom arrow, the first inventor to file world, the post-grant review will apply to all patents, and from the date the patent issues up till 9 months after grant, a post-grant review can be filed where any issue other than best mode, as I indicated earlier, is fair game. At the very end of the arrow at the bottom, it has Interpartes review or covered business method patents. Any of those can be filed after 9 months from the issue date. So if we look at just the arrow at the bottom, in our new world of first inventor to file, within 9 months after grant, any issue other than best mode is fair game during a post-grant review. Then up to 9 months, an Interpartes review can be filed, but the Interpartes review, keep in mind, is limited to 102, 103 issues, but the covered business method patents actually can cover anything, 101s, 112s, but no best mode. Judge Smith, could you tell us a little bit about Interpartes review, post-grant review, and covered business method patents?
Happy to do so. Some of this will, I think certain of the major points will be a re-emphasis of things you have already said, Deputy Director Ray, but let's look at them, as you just mentioned, from the standpoint of the proceedings themselves and their specific requirements. With Interpartes review, all patents are eligible, both first inventor to file patents and first to invent patents. And the person who can bring the action can't be the patent owner and must not have previously filed a civil action challenging the validity. As you mentioned, the grounds for challenging the patent are limited to sections 102 and 103, and only on the basis of prior art consisting of patents or printed publications. It is important to remember that the thought behind the rules, the statute incorporates this, is that multiple proceedings are not to be brought. And in fact, the time window for bringing proceedings is specifically divided so as to accomplish this purpose. And in the first 9 months after the grant of the patent, that's the world of PGR and not the world of IPR, which means, as the slide indicates, that one has to wait either until 9 months after the grant of the patent or the conclusion of a post-grant review before the IPR challenge can be brought. Key to all these proceedings is this thing we call the petition, which is in the framework of AIA proceedings, it is the term uniquely used to describe that document filed by the non-patent owner petitioner in order to invoke a trial. and the petition must make out the case for the trial so that if the petition is granted, then the trial begins. And there are certain specific things which each petition must include. Of course, the fee associated with the filing of the petition must be paid. That's a very important part for the date of the filing of the petition to be accorded. Real parties and interests must be identified. That's also very important because of the estoppel provisions associated with these proceedings. Also, it's very important in order to pay recognition to the contained nature of these proceedings, that the specific claims and grounds of the challenge be identified in the petition. Also to make sure that the proceeding is effective for bringing the issues, framing the issues properly, claim construction must be provided by the petitioner in the petition, and copies of the evidence being relied on also need to be provided. In connection with the whole idea of identifying the real party in interest, the petitioner also should certify that it is not an estopped party. As the Deputy Director mentioned,
Matt?
Yeah, Judge Smith, just one question on the prior slide.
Sure.
There are a number of, I'm sure, people who are going to be filing petitions, as Deputy Director Ray said, in the first week or so because they are under time pressure and the AIA with the one-year rule or for some other reason. And I'm certain that some of the filers are nervous about being assigned a filing date, getting the formalities of the request exactly right. I'm wondering if you could comment on the review process that will take place when somebody files a petition for Interparties review and the circumstances under which the PTAB might see fit to issue a notice of incomplete petition.
Glad you raised that. It gives me, among other things, the opportunity to highlight part of what the office is doing and the board is doing in connection with these proceedings. We're providing a new and we think fairly user-friendly and sophisticated web-based filing system for use by petitioners. And that system is designed specifically to drive the filings toward being able to accord the filing date and to indicate whenever there is a situation that suggests that the filing date might not be granted. Even when there are instances in the process of making the electronic submission that would tend to indicate that a filing date might not be granted or accorded to the filing, the filing activity is allowed to proceed with some indication being provided to the user that there might be an issue. For example, and just as a wild example, the credit card number of credit card digits used in paying the fee is insufficient or something of that kind. But the intention then is that there will be a group of people at the office on the receiving end who get all of that information and perform a verification of the information, and as soon as possible provide an indication to the petitioner that there's something which precludes the date. But the system itself will provide ample clues to prevent the petitioner exiting the submission activity having not actually provided all the information that's necessary.
Thank you.
As the Deputy Director mentioned, the patent owner preliminary response is optional. 3 months are provided for that. In some instances, it will be very useful for a patent owner to provide a preliminary response which might easily end the matter. For example, an adequate showing that the real party in interest making the submission of the petition is stopped by the various estoppel provisions. Also, the Deputy Director mentioned the threshold for institution with IPR. It's reasonable likelihood that a petitioner would prevail. Let's contrast this to more likely than not, which is the standard for the post-grant review. I've heard numerous people comment that they're not sure there's that much of a difference, and they're not sure what either of these necessarily is. I think more likely than not is fairly easy to understand. More than 50% likely that the challenge would be successful. That's, again, post-grant review. And to emphasize what reasonable likelihood is in the context of Interpartes review, it's something which doesn't quite need to be more likely than not.
Judge Smith, one question on the implementation standard, reasonable likelihood that the petitioner would prevail as to at least one of the claims challenged. At least one of the claims would seem to give the board statutory authority to find a reasonable likelihood of success on the merits of the petitioner as to one claim and then proceed on all of the claims. But from reading the trial practice guide, it seems like the board might be moving in the direction of implementing the standard or evaluating the standard on a claim-by-claim basis. Is that what's likely to happen?
Yes.
Okay, so it may be that there's a reasonable likelihood for Claim 1, but not for dependent Claim 10, and then you just move forward on a subset of the claims?
Yes.
Thank you.
The patent owner response is different than the preliminary patent owner response. This is the substantive response of the patent owner after the trial has been instituted. And ample time is given, we believe, in the rules to allow the patent owner to put in that response. Of course, absent a patent owner response in the allotted time, the proceeding would then move forward in the absence of it. The statute specifically provides the opportunity for the patent owner to file an initial motion to amend the claims. The rules require the patent owner to confer with the board in the doing of this activity. That's not suggested or not intended to prevent the filing of the motion. The purpose is to help that motion move the proceeding forward because, of course, there is no as of right second motion to amend that is allowed the patent owner. While post-grant review and Interpartes review are different, they share many of the same features. For example, the filing of a petition in order to instigate the proceedings. There are some differences with regard to first inventor to file and first to invent, but we spoke of those earlier. PGR has a wider scope of challenges, sections 102, 101, 103, 112. And not best mode, again, as the Deputy Director discussed. It's very important to think of time frame with post-grant review. The contrast here, of course, is that with Interpartes review, once the period for such challenges begin, they continue until the patent expires. And that is not true with post-grant review, where the window is only 9 months, and once it's gone, it's gone. So potential petitioners need to pay attention. The standard is also higher, but we discussed that a little while ago.
This is Terry Ray. There also might be some issues, Matt, with your earlier question saying how do the applicant or do the third-party petitioner know whether or not they've provided a complete document. There is some risk in the post-grant review because this 9-month date, if you wait until the very last day and your documentation has a fatal flaw or serious error, there is risk, because if you were outside that 9-month window and you had to file an inter-parties review, the scope of potential weapons, for instance, 101 and 112, would no longer be within your armamentarium.
That's a very good point, and one of the questions that might lead you to, and I understand if you can't answer this particularly for the week of September 16th, but how fast can practitioners expect to get a notice of incomplete petition back in the normal course of these proceedings?
Again, there would likely be some preliminary indication that the web-based system itself will provide to petitioners in terms of an after-the-fact review by the board and a people-generated notice. We're not sure of the timing of that right now. I can say we think it will be on the order of days and not weeks.
This is Andy. Just want to add that there's also that risk in inter-party review because of the 1-year litigation bar.
That's correct. That's a good point.
Judge Smith, we also have an audience question specifically relating to the electronic filing system you were talking about. And the audience question is whether or not it will be possible for the public to view inter-parties review petitions that are going to be filed.
Well, that are going to be filed, that have been filed, yes. Except in instances where there is a showing of need for secrecy and some sort of protective order that covers the petition itself, which is highly, will only happen in very rare instances. The whole system is designed to allow registered users to have full visibility of the various proceedings, including proceedings to which an individual is not a party.
And this is the patent review processing system, not PAIR, right?
That's right. Patent review processing system, or as we're calling it here, PERPS. Or on our better days, we call it purpose. The covered business methods proceedings. Here again, we already have touched on some salient aspects of it. One of the key things to have in mind is that the petitioner, in addition to meeting other petitioner requirements, must be sued or charged with infringement. And the practice guide speaks in some greater detail about what it means to be sued or charged with infringement for purposes of these proceedings. Also, it's important to note that the petitioner has the burden of establishing that the patent is eligible for covered business method review, which means, among other things, establishing that or rebutting that the exception applies, which is to say that it needs to be able to show that the invention of the challenge patent is not covering a technological invention. Eligible patents for the covered business method review. It covers both first to invent and first inventor to file patents, and that definition is provided in the statute and in the rules for what a covered business method patent is. Generally, it's defined as a method or apparatus for performing data processing or other operations for financial product or service, as long as it's not a technological invention. Now the Deputy Director will address the umbrella rules.
The umbrella rules actually are a statutory requirement, and it's some of my favorite bedtime reading, and you have to identify the real parties in interest. We've provided a great deal of guidance. Congress gave us a bit of guidance. We've tried in the umbrella rules to provide additional guidance. We realize that always identifying the real parties in interest is not something that's very clear-cut, and oftentimes is going to require some judgment, but there is a considerable amount of case law as to who is a real party in interest, and we hope that those will guide our outside practitioners. The second bullet point here goes to the practice guide, and those are it identifies some factors that can be considered in determining whether a party constitutes a real party in interest or privy. So we've given you as much guidance as we could at the time. In our notice of proposed rulemaking, there were a few people, but not many, who had questions, and we tried to address them in our final rules. Also, both the petitioner and patent owner obviously have to provide a certain amount of information so that we could conduct these proceedings in an efficient manner, and the identification of simple things such as lead and backup counsel and contact information is something that's very important to Judge Smith and his colleagues in terms of doing their job. Now, the umbrella rules, in our notice of proposed rulemaking, before they were final, a number of practitioners actually provided comments in this area. And a lot of people said that, well, if someone is going to be admitted, number one, can they be admitted pro hoc vice? And in the current world that we exist before the Board of Patent Appeals and Interferences, indeed, we do recognize outside practitioners and admit them pro hoc vice. So we actually have precedent in that area, but there's the potential that in these AIA trial proceedings world that perhaps the scope of outside practitioners may increase. We do think that that is likely, so we were able to look at the comments provided by third parties, and we've emphasized and clearly set forth in the practice guide that the lead counsel must be a registered practitioner. Actually, it's in the umbrella rule. The lead counsel has to be a registered practitioner. Now, perhaps the greatest case, the most likely case where a non-registered practitioner would indeed be entered or admitted rather pro hoc vice is counsel who is already experienced working with a particular client, perhaps is handling a related litigation, and they know the technology, they know the client, they know the subject matter at issue. So one of these trial proceedings would somewhat be second nature to them since they already know the issues. Other than that, I can't give you any specific guidance. Judge Smith and his colleagues will make the best decision that they can on that issue, but we realize that more practitioners will likely be admitted pro hoc vice for these proceedings. The next point is, I guess it's the slide that I like to say, we heard you. In our notice of proposed rulemaking, we wanted to detour third-party petitioners from challenging too many claims in a patent simply because based on our current reexamination experience, the number of claims is fairly correlated, if not directly related, to the amount of time each one of these procedures take. So we wanted to actually dissuade third-party petitioners from challenging unnecessary claims in patents so that we could control and more better focus our efforts. However, we realized that for outside practitioners, that perhaps was not the appropriate approach, so we have now backed down. So the base fee for 20 claims in an Interparties review is $27,200, and then for each additional claim, it's $600. But my recommendation to third-party practitioners is indeed limit the scope of the claims that you are electing to challenge just because it makes your job easier also, and the scope of any estoppel is actually minimized for claims that we do not address in these proceedings. So it actually is a win-win for both parties. For post-grant review and covered business methods, that's a little bit higher fee because, once again, the scope of the issues are greater. 101s and 112s are included there. So it's $35,800 with $800 for each additional claim over 20. For derivation proceedings, we just charged for the petitions phase, and that is the $400 because in derivation, the potential patent owner is alleging that the subject matter of which they invented was actually inadvertently inserted in somebody else's application. So for derivation, we were not required by Congress to give the higher increased fees. Once again, we heard you. In our notice of proposed rulemaking, our page limits did not make a lot of people happy, so we've increased all of our page limits for each of the proceedings by 10 pages. So in the case of Interparties review, it's a maximum of 60. PostGrant review and covered business method patents, it's 80 pages, and derivation, it's 60 pages. So we increased the number of that. For claim charts, we now allow single spacing, and the statement of material facts in a petitioner motion is now found to be optional.
Continuing on the umbrella rules for just a little bit longer, it should be observed that the statute grants the office the authority to set standards and procedures for the taking of discovery. I think it's fairly agreed by many people that the discovery aspect of these trials creates the most significant challenge in terms of moving the trials along to a timely conclusion. Some of the things that possibly will help with moving discovery along is to, for example, allow the parties to agree to discovery between themselves. So cooperative parties can certainly help make this work better. That said, there are also mandatory mandatory initial disclosures that are part of discovery. There's routine discovery required of the parties, and then there's the opportunity for additional discovery where it is seen that that discovery will help drive a fair and correct result. The rules go into some detail as to what constitutes routine discovery. The one thing I'd emphasize here is that when you have put forward a declaration, expect that the other side will want to cross-examine the declarant, and that should be a routine part of what happens. Similarly, routine should be inconsistent statements that the parties know of, that the other side should not have to go in search of those things because you should provide them. They are required.
Judge Smith, one question on inconsistent statements. In the final rule, there was an inclusion of corporate officers in the parties who are charged with the duty to provide information consisting of inconsistent statements to the office. Can you comment on the reasoning for including corporate officers and whether or not that actually requires practitioners to go and ask corporate officers whether they are aware of any inconsistent information?
Let me respond to that, not so much by speaking to the inclusion of corporate officers, but speaking to another one of these things that, as the Deputy Director indicates, allow the office to show that we heard and responded to the comments. The comments with regard to who should be included, whose inconsistent statements and other discoveries should be included, or who might be deposed, had much more to do with whether the scope of the rule was too broad. And for example, if a party happened to be a company with 40,000 employees, whether all 40,000 employees might be fair game to the other side. So what the revised rules do is narrow the scope of the discovery, which necessarily, when drawn tightly, would not exclude corporate officers if they have participated in the underlying matter in such a way as to have made inconsistent statements.
I see. Thank you.
The parties may agree to additional discovery beyond what's, for example, routine, and the parties may even agree to discovery that ends up being required of them. For example, agreeing that mandatory disclosures of the kind in Rule 26 of the Federal Rules will apply in these proceedings. Another area of great interest has been as to whether or not the petitioner might be allowed to bring forward additional information in support of a challenge of the patent after the petition has been filed. This will be allowed, but only in instances, or in a limited time window, within a month, and with a showing that it that the information now sought to be brought forward could not reasonably have been obtained earlier, and that consideration of the information would be in the interest of justice. Generally, I think this is a fairly high standard because we want to encourage petitioners to present all of what they have to present up front. We've already talked quite a bit about the estoppels, and there's been a fair amount of discussion of that in response to the proposed rules, and even, in fact, during the drafting of the Act. So for now, we'll pass on giving more details about that here, other than to say this is very important. Multiple bites at the apple, as they say, is not what the intention was with these trials, so that the parties will be held to, or those petitioners seeking to be parties will only allowed to be parties where they can show they are not estopped.
So this ends the PTO formal presentation, and we'd now like to direct your attention to Matt Smith, who will tell you petitioner strategy and how you can make that threshold or hurdle and actually have one of these proceedings initiated.
Thank you very much, Deputy Director Ray and Chief Judge Smith. Let's step back a minute from strategic considerations and just think about the final rules and how they may have changed the balance of power. And this is a relatively, I think, short evaluation because the major changes, I think, were offsetting. There weren't a lot of major changes, and to the extent there were major changes, I think they happened in both directions in a very reasoned way. The major changes as I see them were, first of all, in favor of the petitioner adding more flexibility in the petition document, and that is principally relaxing some of the required sections like Statement of Material Facts and allowing more pages, both the 10 extra pages and the single spacing of claim charts. That took us from a 50-page double-spaced 14-point font petition to, I think, effectively twice that or so. And if you look at how Interparties reexamination requests were being formulated in the past, you may have 200 to 500 single-spaced 12-point pages. So it would have been extremely difficult to meet the 50-page limitation. And I think this change in the rules makes the Interparties review proceeding much more tenable from the petitioner's perspective. On the other side, of course, more flexibility was given in motions to amend the claims. There are fewer required components to those motions, so that helps the patent owner. As Judge Smith just mentioned, there was a narrowing of the patent owner estoppel, so the patent owner will still be allowed to present patentably distinct claims in related proceedings on the same patent. That allows the patent owner, of course, to potentially recover some claim scope if the claims have been invalidated in Interparties review, as long as there's a reason for distinguishing the results in the future proceeding from the results in the IPR in a patentably distinct way. And then, of course, the proceedings were increased in length, at least over the practice guide schedule. An additional month was given for the patent owner to prepare a preliminary response, which, of course, helps the patent owner. The time was for the patent owner's principal response and the petitioner's reply was adjusted to be 3 months for each, and that balances things out there. So plus 1 month overall. For patent owners who are subject to rejections, of course, that helps the patent owner. If the proceeding is going badly for the petitioner, it could help the petitioner. It just depends on the substance at that point. Let me just touch on a few strategic points for petitioners. I think the overall strategic effect of the IPR proceeding, which is really the first one that's going to be used in any significant way, is going to depend on the availability of stays of litigation pending the Interparties review proceeding. And the current practice in Interparties reexamination, of course, varies from court to court, from judge to judge. There are some courts that like stays, some courts that don't like stays, and some courts that are really in the middle, going factor by factor on every case. I think in the present circumstances for Interparties review, we're going to have a few key decision points. As Deputy Director Ray noted, there's likely to be a number of filings on or shortly after September 16th. That's going to give a group of petitions that are going to sort of travel through the office together and reach various procedural points together. Some of the petitioners are going to file motions to stay in court right away. So after a few months, we'll presumably have the first decisions from courts, and we'll see what courts are thinking about this proceeding. When those petitions reach the sort of 5 or 6 month stage where we can expect decisions on whether or not to go forward with the trial, we're going to see another flurry of motions to stay filed, and a few months after that, we're going to see what courts think about those. Remember, in the trial decision, the decision to institute trial, I should say, you're essentially going to have the board saying for a certain set of claims that there is a reasonable likelihood of success, and from this point forward, the proceeding is very, very likely to take 12 months or less. And that's a fundamentally different argument that one is making to the court as opposed to what one would have made in an Interparties reexamination proceeding. So we'll have to see what the courts do with that. And then about a year later, we'll start to have the final written decisions of the Patent Office. And I imagine that that will also be a point for people to go back to court, both patent owners going back to court to try to enforce the estoppel that is triggered by the final written decision, and petitioners going back to court seeking to stay because the estoppel has kicked in, yet the claims are rejected, and because the IPR petition is being appealed to the Federal Circuit. So I think we'll have those key decision points coming up in the future that will tell us a lot about how the Interparties review proceeding has affected the balance of power between typically accused infringers and typical patent owners. A few strategic considerations to make in the case. There's a lot more flexibility in the petition, certainly for the page limits and the required components, but I think you're still going to have to narrow the prior art case you're making as compared to what one might have done in an Interparties reexamination proceeding. And I think one of the ways that's going to express itself is by grouping of prior art in obviousness type combinations. So where we might before have set out 3 different proposed rejections, Smith in view of Jones, Johnson in view of Miller, Cooper in view of Wilson, or something like that, there's a certain amount of administrative overhead that goes toward separating out those rejections. We may simply take the approach that, for example, the Supreme Court took in KSR, where it simply evaluated all of the available prior art, discussed the way the prior art evidenced certain forces in the industry, and how the prior art as a whole rendered the claims obvious. So you may start to see challenges to validity that include more references, whereas I think that's an instinct that most patent practitioners don't have. If they see more references than an obviousness challenge, I think the claims are less obvious. But I think the reverse may start to become true. The second big question is how the petitioner uses experts. I think this is a key decision point for petitioners. I'm just going to mention this dilemma. When we make an invalidity case in litigation, most of us wouldn't consider not having an expert. It's very, very risky to do that. In reexamination, we have the other extreme. Quite often, we go forward with just the prior art references and no expert testimony and allow the examiner to sort it out. This is, I think, somewhere in between. We see many decisions coming out of interference practice where expert testimony is effectively required to interpret prior art references. However, it's not quite the same as submitting an invalidity case to the jury. Now, the countervailing consideration is, of course, that the more expert testimony one submits, the more the expert will be subjected to cross-examination. So there's a balancing point in there that I think petitioners are going to have to find very quickly. Secondary evidence, I think, may become more important. In my experience, secondary evidence is given more consideration the farther one goes up the appeal chain. So the board will typically give more consideration to secondary evidence than examiners will, and the Federal Circuit will typically give more consideration to secondary evidence than the board will. Because the petitioner is filing first and is expected to submit a lot of the evidence with the petition, it may be in the petitioner's interest to start developing secondary evidence of obviousness right away. Secondary evidence can be evidence of obviousness just as it can be evidence of non-obviousness, and I think that may start happening. And there's estoppel management. The Section 315E estoppels are claim by claim, as Deputy Director Ray mentioned. one potential strategy is to file on one set of claims first, then file on other claims after the institution decision or the final written decision, thereby dividing up the estoppel effect. In other words, once you know what the PTAB is likely to do for one claim, you might file on a similar claim. Potential downsides, and there are quite a number of them, are that the PTAB, of course, has discretion with the second request to take into account the fact that a first request was filed, and the 12-year limitation in the event of, the 12-month limitation in the event of joinder dissolves at the point where you have two IPR petitions coming together. So there's no longer the 12-month guarantee if you're filing a request that will later have to be joined. Let me hand it over now to Andy Baluch, who will talk a little bit about the patent owner strategy.
Thanks, Matt. So from the patent owner's perspective, let's start with the big picture strategy. The best outcome, I think especially if there's co-pending litigation, is to defeat the petition. Although no estoppel attaches at this point, the board's decision that even some of the claims don't meet the inter-party review threshold, which is applied claim by claim on the reasonable likelihood of success standard, that determination will be extremely helpful for you as the patent owner in litigation, for example, to get a preliminary injunction or to show willfulness by the petitioner. However, if the patent is granted, if the petition is granted and the case is proceeding, then obviously the best case scenario is having all original claims confirmed. Estoppel attaches, and the patent is essentially bulletproof from any invalidity arguments the petitioner raised or reasonably could have raised. And this outcome might even be better than defeating the petition in some cases, for example, where there's no litigation yet and only later you go and enforce the patent. The patent will be much stronger because it went through that inter-party review. Failing that, it is still a victory for the patent owner if you save the original dependent claims that cover the competitor's product, even if you do lose the independent claims. However, if you must amend the claims, and the new substitute claims are not substantially identical to the original claims, then past damages will and future damages may be wiped out by intervening rights. Settlement is available, unlike in re-exams, and many times it will make more sense to settle than going through the uncertainty of a year-long PTO proceeding plus a federal circuit appeal. So that's the game plan for the patent owner in a broad sense. So practically speaking, what do you do on Monday morning, September 17, when you as the patent owner come into work and you see you've been hit with a petition for inter-party review or covered business method review? First, don't panic. Within 21 days, you must designate a lead and backup counsel and file the other mandatory notices. And in the first 3 months, there is going to be a lot to do. Behind the scenes, you as the patent owner, you're pulling together everything you need for the preliminary patent owner response, and you're finding experts in case the petition is granted. If there's confidential material in the petition, you'll need to get access to it, and to do that, you'll need to agree to a protective order. Also, you'll want to quickly investigate if the one-year litigation bar or other estoppel applies. For example, if the named petitioner is in privity with any defendant in litigation involving this patent. And to do that, you'll need to ask the board for pretrial discovery so you can investigate these possible connections to the named petitioner. Turning to the preliminary patent owner response. This is where you argue that the board shouldn't even bother initiating a trial. As was mentioned, it's optional to file this preliminary response, but in it, you argue things like lack of standing because of estoppel or litigation bar, as well as attacking the merits of the petitioner's case. It's also interesting that the board may deny the petition if it doesn't think it can complete the review in a timely manner. So if I'm a patent owner with hundreds of claims being challenged, I'm going to be arguing to the board that this trial is going to take longer than a year to complete and therefore should be denied. In terms of new testimonial evidence, however, The patent owner, unlike the petitioner, cannot rely on newly prepared testimony at this point unless the board has given you permission on the issue of standing, for example. So that's why it's essential very early on to ask the board for permission for this additional discovery.
Andy, this is Matt. Let me jump in and give the New York CLE code, which is R4XTE. That's R4XTE. And let me also ask you a question on your last slide. It's still possible for the patent owner to present non-testimonial evidence, right? And if so, can you talk about what that might be?
So the prohibition applies to new testimonial evidence. And so potentially, if there's previously prepared declarations, affidavits, transcripts from a litigation, that might be able to come in without violating the no new testimony rule.
What about things like prior art?
Oh, of course. That is not testimony. It is what it is. It's prior art, the prior art reference or patent. So kind of like with a response to a office action, you're submitting documents that teach away, for example. And indeed, one of the explicit things you can argue according to the trial practice guide is that the prior art teaches or suggests a way.
Thank you.
All is not lost, though. If they do grant the petition, you can still request rehearing, but you have to do that within 14 days of the decision to institute trial. The initial decision is reviewed for abuse of discretion, so it's best to key your arguments to legal error more so than factual error, like statutory interpretation. So in this regard, the legislative history might be helpful. Congress intended reasonable likelihood to effectively require a prima facie case of unpatentability. So as the patent owner, you're pushing up on this standard, ratcheting it up as Congress intended, and attacking the prima facie case of in the petition. Amendments. If the board does finally decide that there must be a trial, then as the patent owner, you should start thinking about whether you need to amend the claims. We've already talked about the various restrictions on amendment practice. What this effectively means is that inter-party review and post-grant review, covered business method review, it is not going to look like re-exams where patent owners have added hundreds of new claims in the past. Also, the fact that the amendment has to, quote, respond to a ground of unpatentability, unquote, means that you cannot amend solely to cover commercial embodiments, for example. You're going to need to show that the amendment is a basis for overcoming the petitioner's challenge. Also, one interesting tidbit in the trial guide is that the board can deny the proposed amendment if the original claims are determined to be patentable. This is great news for patent owners, potentially, because you can argue that both the original and proposed substitute claims are separately patentable. And if the board agrees, then you avoid unnecessarily amending the original patentable claims and thereby avoid triggering the intervening rights. Finally, patent owners should not forget that they have a statutory right to file a reissue and or ex parte re-exam of the same patent. These proceedings offer flexibilities that are not available in inter-party review, like broadening, adding new claims, and filing a civil action under Section 145 for reissues. But you're going to need to be prepared to explain why the board should not exercise its discretion under the AIA to stay, transfer, consolidate, or terminate those other proceedings. Basically, this statutory provision gives the board lots of room to do pretty much anything they want with those other proceedings. And you'll also need to initiate these proceedings before any patentee estoppel is triggered under the rules by a final adverse board decision. So I'll end here, and we can go into more details during Q&A.
Thank you, everybody. We'll open it up to Q&A now. If anybody has any questions, please ask it through the Q&A forum. We have a couple of audience questions that I'd like to address. The first question is, will patentee estoppel disallow pursuit of broader claims where secondary evidence, other than commercial success, is developed and presented in a continuation after an IPR or PGR? So, Judge Smith, I understand that to mean if I lose as a patent owner in an IPR and have a continuation application where I file a similar claim but new evidence, would I be allowed to go forward on that continuation application under 37 CFR 42.73D?
Likely not.
Okay.
And again, we're talking about in the wake of an adverse determination. So an even narrower claim was not, did not survive the challenge, and the question then becomes whether, well, that essentially answers it.
Okay. Had a number of requests to repeat the CLE code for New York. It is R as in Roger, the number 4, X as in xylophone, T as in Ted, and E as in Edgar. R4XTE. Another question for Deputy Director Ray and Chief Judge Smith. I'm wondering if you could talk about some of the lead-up that has gone into preparing for the availability of Interparties review and covered business method patent review, and in particular, the new PTAB judges that have been hired and how they're integrating into the overall system.
Well, we already spoke to some extent about a major part of our effort, which involves the new computer system that will handle matters. With regard to the human resources, many things have been going on at the board to expand its capabilities, some very directly related to the AIA trials and some indirectly related as we've tried to address challenges we face with our ex parte appeals from examination. Generally, the board sits in a much better position today to handle the incoming work than it did, say, a year ago. Looking back exactly a year, we had just over 90 judges on the board, and by the end of September this year, the board will be comprised of about 165 judges, which is a substantial increase in its capabilities, and that number will be even larger by December, probably somewhere around the 180, 185 judge mark. The talents and well, as many of you will recall, when a famous basketball player decided to take his talents to Miami Beach, there was a lot of reaction to that. The reaction here is very positive about the many outstanding patent lawyers who have chosen to take their talents to the U.S. PTO, and they've come from among various places: the Department of Justice Trial Section, the International Trade Commission, several very prominent law firms, from the best of the patent examiners and others at the patent office, including the solicitor's office. So we're very pleased with the way all that has helped increase our capability.
Matt, could I ask Chief Judge Smith a very quick question?
Of course.
Okay, so the PRPS web system that will be available to all of our user community to sort of see what's been filed and to follow it, just because a lot of people are curious about these procedures, where on the USPTO website will that link likely be? Have we made a determination quite yet as to where it will be on our website, or if it would be called the PRPS system, or will be under the board section of our website? because I'm sure each one of you are eager when you start up your computers on the 17th to see what presents were filed with us.
It will definitely be on the board portion of the website, but at least for some time, I expect it'll be linked through also to the AIA webpage. Right now, we also have some notices there about how members of the public can participate in helping us fine-tune the system even between now and September. We tested it with some members of the public last week. We have a session planned for unveiling it and showing it to the public. I think it's the 6th of September. That date may have changed. You can check on the AIA website for when it's there. So plenty of information will be available as to what its capabilities are and specific information in various parts of the website as to how to get to it.
Judge Smith, Deputy Director Ray, there are a number of audience questions still outstanding. I think a few of them address strategic issues that we could probably talk about all day. I just want to finish with one question that I think Judge Smith can answer relatively quickly. Is the initial decision to institute trial going to include a substantive opinion, or is it simply going to be a trial yes, trial no, and here are the issues we're going forward on?
The intention is to indicate to the parties the reason for proceeding or not proceeding.
I see. So you would be explaining at least briefly why the statutory threshold has been met for certain issues but not for other issues, if that's the case.
Yes.
Yeah, and keep in mind that that's not an appealable decision. So whether or not the threshold was met, we don't have to do a long, lengthy opinion because our decision is final. But we want to provide sufficient information to third-party petitioners should they have access to additional information and be able to refile.
Well, thank you very much, and thank you for everyone on the line for joining us today. Unfortunately, we need to release our PTO guest at this time. If anybody has any additional questions, and I know there are a few outstanding, feel free to contact Andy or myself at the information that's provided on this slide. The recorded webcast and PowerPoint materials will be posted on our website at www.foley.com. CLE takes about 6 to 8 weeks to process, and confirmations will be distributed directly. This concludes our web conference discussion for today. Special thanks to our guest speakers and the audience for your time. Thank you.
Thank you all for allowing us to participate.
Thank you.
Ladies and gentlemen, thank you for participating in today's conference. This does conclude the program, and you may all disconnect. Everyone have a great day. Speakers, please stand by.